So thanks everybody for coming. I'm gonna let Erin take over in a minute or two, but wanted to introduce her quickly. She is a partner at Surprenant and Beneski, which is an elder law company in Massachusetts. So they're pretty much exclusively focused on estate planning and elder law, and they have been for years. So definitely an authority in that area. And Erin has been with the company for 19 years, I believe. Um, Graduate of UMass Dartmouth Law School, mother of three. So we're going to keep it pretty high level tonight, but Erin is extremely knowledgeable when it comes to this area of the law. And more importantly and uniquely, she is very down to earth. She's very easy to talk to. So I hope at the end of this we'll open it up for Q&A. I hope if you have questions you'll feel free to ask, and when the time comes, I hope you'll set up an appointment with Erin to just get some more individual color on your situation. So I'm going to hand it over to Erin for now. And yeah, Erin, you can take it from here.
All right, perfect. Thank you so much, Brendan. Welcome, everyone. Thank you so much for taking some time out of your evening to learn a little bit more about estate planning and what our firm might be able to assist you with. As Brendan mentioned, I am a partner with the law firm of Surprenant and Beneski. We focus exclusively on the areas of estate planning, elder law, asset protection, probate avoidance. So all of our professional affiliations, all of our educational efforts are focused in this area. We don't do divorce law, family law, real estate, anything like that, because we want to feel confident that when we're meeting with folks that we are making the best planning recommendations possible for you. So the firm is myself, along with the two managing partners, Dan Surprenant and Michelle Beneski, who are actually brother and sister. In addition to the three partners, we have three associate attorneys, and we have a wonderful, dedicated, knowledgeable support staff that helps us guide our clients as they're working their way through the estate planning process. We have three locations. We have offices located in New Bedford, in Easton, and Hyannis. We also try to make the estate planning process as easy for folks to access as possible. So we also offer consultations via Zoom, via phone. We regularly go to people's homes if they need that, assisted livings, nursing homes. So we try to be really flexible to make sure that if people need counsel in estate planning, we can be there to help them. So tonight we're going to go through an estate planning overview. At the end of the program, I will take questions. So please feel free to, jot down anything that you have a question on, any of the materials that we're covering. I do just ask that you try to keep the questions general to the material that we're covering. This is not really the best place to answer very fact-specific questions about your situation. I wouldn't want to, provide inappropriate guidance because I don't understand the entirety of your situation. But certainly if you have a general question about anything I'm going over, you can certainly save it to ask at the end, or if you want to put it in the chat, then I'll make sure to go back to that at the end of the presentation. So again, we're going to talk about an estate planning overview. And the four topics we're going to cover are foundational documents in probate, advanced care planning, trust planning, and minimizing taxes. And then the best ways to protect your children, grandchildren, and special needs beneficiaries from things like creditors, divorce, and to make sure that they remain eligible for any benefits that they might be entitled to. So to get started, we're going to talk about foundational documents in probate. What is an estate plan? What is probate? And what are some of the ways that you can avoid it? And what goes into creating or establishing a will? So, an estate plan is a set of documents that you leave behind for your family and your loved ones, giving them instructions on how you want things to be handled in the event that you become incapacitated, and then certainly after you've passed away. So, it consists of documents that you create during your lifetime, and it helps to resolve any conflicts or legal issues that might arise down the road. Estate plans can be created for a variety of different reasons. It really just depends on what your goals and your concerns are. So they can be created for things like protecting assets from the cost of long-term care, avoiding probate when you pass away, um, minimizing your estate taxes. So for as many different types of families there are out there, there are different types of estate plans that can be created to address those specific concerns. In our office, what we refer to as your foundational documents are your durable power of attorney, healthcare proxy, HIPAA release, advance directive, and your last will and testament. And these documents are really important for people of all ages. A lot of folks think, I don't need a power of attorney or a healthcare proxy until I'm, in my 80s and I'm sick. But once someone turns 18, once they are legally an adult in the eyes of the law, no one gets to automatically just step into their shoes to make decisions for them. So even someone who is younger, who may not have, a substantial estate, should at a minimum have a good durable power of attorney and a healthcare proxy in place. So of the 5 foundational documents, really the two that are the most critical, in my opinion, are the durable power of attorney and the healthcare proxy. With the durable power of attorney, that's the document where you set forth who you want to step into your shoes to make legal and financial decisions for you if you either could not do that for yourself because of an incapacity, or if you simply just reach a point in your life where you need some assistance. Maybe it's difficult for you to get to the bank, or you have difficulty signing checks and you want to name a trusted person to be able to assist you in doing those things. A lot of people think that if you are married, your spouse automatically gets to do those things for you, but that's not true. Again, if you are an adult over the age of 18, if you have not specifically authorized someone in a well-written document that they have the power to make those decisions for you, they can't. Not without having to go into court and petition a judge to become your conservator. That's who the court says gets to make legal and financial decisions for you. Now, that conservatorship process is expensive. It typically costs about $6,000 or $7,000 between court costs and attorney's fees and publication notices. It's also time consuming. It typically takes about 3 to 4 months before you get the authorities that you need in order to be able to handle things. So having a good power of attorney can rule out your family having to go into probate court and, spend that kind of money and take that kind of time. The other side of the coin is the healthcare proxy. So the healthcare proxy is the document that says who you would want to make medical decisions for you if you lacked the capacity to do that. So the durable power of attorney is a shared role. Even if you have capacity, you can authorize someone to use it. But with the healthcare proxy, as long as you have capacity, you are in the driver's seat with regard to your medical decision making. But if your doctor should make the determination that you lack the capacity to make your medical decisions, the healthcare proxy says who you would want to do that for you. In both of those documents, you should name both a primary decision maker as well as a backup in case that person isn't able to serve for whatever reason. Now, having a good healthcare proxy in place will avoid the need for your family or your loved ones having to go into court and petition a judge to become your guardian. So if you lose capacity and you don't have a healthcare proxy in place, the only way that someone can make your medical decisions for you is by going into court and petitioning a judge to become your guardian. Same 3 to 4 month time delay, same $6,000 to $7,000 in costs. And, especially with medical decision making, time is of the essence. So you don't want your loved ones to have to be tied up in that court process when it could have been completely avoided by having a good and thorough healthcare proxy in place. Now, with the durable power of attorney, you may have one at home, you may have done one years ago. That's a 1 or 2 pager that, essentially says this person can do everything for me that I can do for myself. Unfortunately, that doesn't cut the mustard anymore. Your documents need to be really specific about the powers that you are giving to your agent. So it can't just be that broad, or it's likely not going to be accepted by the bank or the financial institution where they're trying to, take some action on your behalf. Same thing with the healthcare proxy. You can, get those at your doctor's office, you can get them at the hospital, but those are, frankly, very generic. And the healthcare proxies that we prepare for our clients are more thorough and, contemplate some of the issues and the concerns that might arise in your retirement years, such as, what happens if you need to be transitioned to a long-term care facility? What happens if you have a diagnosis of Alzheimer's or another form of dementia, and your doctor recommends a specific type of medication that are classified as antipsychotics? In both of those examples, if you haven't given express authority to your healthcare proxy to be able to consent to that medication or consent to your going into a facility, they have to go into court and get a judge's permission. So, having that generic healthcare proxy is certainly better than not having one at all, but you may want to consider, updating that to something more thorough. So in addition to the power of attorney and the healthcare proxy, we also recommend something called a HIPAA authorization. And the HIPAA authorization is a document where you say who can have access to your protected medical information. So it's not decision-making, that's the healthcare proxy. But the HIPAA authorization allows you to name specific people that you would want to have access to your protected medical information. So I want my spouse or my children or my siblings or my friends or whomever to be able to talk to the doctors if I'm in the hospital, talk to my health insurance company about a billing issue that I'm having, talk to my pharmacist about my medications. Without that authorization, they're not going to be able to have access to any of that information. So the HIPAA authorization really opens up the door of communication for your loved ones with your physicians and other people who have access to your medical information. And then the third healthcare related document is an advance directive. And that's the document where you set forth the type of care that you want in different situations. You want life support in X situation. You don't want life support in Y situation. You want to be cared for exclusively at home, or you're okay with transitioning to an assisted living or a nursing home. You want to be buried versus cremated. In Massachusetts, the advance directive is not a legally binding document. It's meant to provide guidance to the people that you name in your healthcare proxy, so that if they do have to step into your shoes to make those, difficult end-of-life decisions, there is something that they can look to make sure that they're acting in accordance with your wishes. So that can be a very helpful tool for your family during a difficult time. And then the last of the 5 foundational documents is your will. So your will should contain certain provisions. It should deal with how real estate can be sold, how personal property, things like your jewelry and your furniture, how you might want that distributed, include any provisions for minor beneficiaries. It should name a primary and then an alternate personal representative, which used to be known as an executor. And then for married couples, you may have a will in place that we would refer to as an I love you will. And an I love you will basically says I leave everything to my spouse, and if my spouse has predeceased me, to whoever else. But as you age, the likelihood that one spouse will need long-term care increases. And that likelihood increases even further if the healthier of the two spouses unexpectedly passes first. So we're going to talk more about, mass health and long-term care a bit later in the program. But if your spouse needs care, or would likely need care if you were to pass first and they no longer had that built-in caregiver in place, and we jumped through all the hoops we needed to jump through in order to qualify them for mass health, and then you, as the healthier spouse, unexpectedly pass first, and your will says, leave everything to my spouse. That just undid all of the planning that we did to qualify them for mass health benefits. And it's much more difficult to preserve assets from the cost of long-term care for a single person versus a married couple. So in those situations, we often recommend creating an enhanced will that includes a testamentary supplemental needs trust for your surviving spouse. And we do that because there's a mass health regulation that says if assets go through your will, your home, money, whatever the case may be, goes through your will and into this trust for your surviving spouse, those assets are immediately protected from the cost of long-term care. So even if your spouse is already in a facility or would need care imminently after your passing, those assets don't have to be spent down on nursing home care to the tune of, $15,000, $16,000 per month. So it's a great tool to use in crisis planning to be able to preserve assets. Now, a common misconception about having a will is that your will avoids probate, but that is not true. Anything that you own individually when you pass, so if there's no joint owner, if there's no beneficiary designation, then the way that that asset gets to your beneficiaries is through the probate court process. And your will serves as an instruction to the court on how you want those assets to be distributed. In Massachusetts, the probate court process typically takes about a year. And on average, between court costs and filing fees and attorney time and publication notices, you're looking at about $6,000 to $7,000 in cost over that year's time. Now, there are ways that you can avoid probate. If you have a joint owner on a bank account, if you have a beneficiary designation on your IRA or your life insurance, or if you have assets that are owned by a trust, all of those will avoid probate and pass, immediately and privately to the joint owner or the beneficiary or the beneficiaries of the trust. So there are different ways that you can avoid probate if that is a concern of yours. So those are the 5 foundational documents: the durable power of attorney, the healthcare proxy, the HIPAA authorization, the advance directive, and the will. And now we're going to move into topic 2, advanced care planning. So we're going to talk generally about long-term care costs and your planning options and what are the rules surrounding mass health. We are not going to get into specific strategies in order to help someone become eligible for mass health, because those are very fact specific. But we are going to generally talk about the program rules. I would just say if you know someone who hasn't done prior planning and they now need long-term care, don't just assume it's a foregone conclusion that nothing can be done at this point. I would really strongly recommend that they see an elder law attorney to learn what options they may have. If not necessarily to protect assets, at least to try to stretch them as far as they can possibly go. So just a little food for thought. 70% of all Americans over the age of 65 will spend some time in long-term care. And more than 65 million people, which is roughly 29% of the US population, provide care for a chronically ill, disabled, or aging family member or friend during any given year. They spend on average about 20 hours per week providing care for their loved ones. And the unfortunate result of all of that caregiving is that 40% of caregivers will die before the one they're caring for because they simply burn themselves out. You know, they stop caring for themselves when they start caring for someone else. And if you yourself have served as a caregiver, you know, it can be very rewarding, but also draining mentally, physically. So it's really important to try to take advantage of as many supports in the community as you possibly can so that you can continue to provide that home care for your loved one. So some in-home support options can include Meals on Wheels programs, personal care attendants, transportation to and from doctor's appointments. Adult Day Health is a really wonderful program that is, I think, underutilized. Adult Day Health centers often have both a social and a medical component. So it's a place where you can, you know, safely send your loved one so that they can socialize with other people. You know, sometimes being cared for at home, especially during these winter months, can be very isolating. So it's a way for them to get out, have some socialization, be in a safe environment, and often there's nurses on staff. So if there's medication that needs to be administered throughout the day, that can be done. So it's an opportunity both for the senior to be able to thrive, but also to give the caregiver a bit of a break. So, you know, maybe they can work or, you know, tend to their own needs. So those are some really wonderful in-home support options that you can take advantage of. How do you afford these in-home care options? You can certainly private pay. If you have some long-term care insurance, that will often have a home care benefit that can help pay for some of those services. But if you can't afford to private pay and you don't have insurance that's going to help, many people will try to qualify for Mass Health. Mass Health in general has a $2,000 asset limit, and there's an income threshold. So if you simply just try to apply for Mass Health Standard in the community, the income threshold is very low. It's about $1,000 a month. And for a lot of folks, you know, if they're getting Social Security and a pension, they have more income than that. So what we will often try to do for our clients is have them qualify for something called the Frail Elder Waiver. So when applying for that program, the local elder service agency comes out and they do a screening of your medical needs. And if you need a certain amount of care at home, it bumps that income threshold up to just over $2,800 a month. So it allows a lot more people to qualify for the benefit. And that can really help provide for services at home. And that can also help pay for the adult day health programs as well. So how much does long-term care cost? So the average cost of nursing home care is $12,000 to $15,000 per month. I would say it's trending higher than that. It is not out of the ordinary to see daily private pay rates in facilities in excess of $500 a day. So it's enormously expensive to private pay for long-term care. The average cost of an assisted living is anywhere from about $4,500 a month to $8,000 per month. And that cost can go even higher than that if you are someone who has a memory impairment and you need to be in a memory care unit of an assisted living. You can see that be $10,000, $11,000, $12,000 per month, depending on your area. So again, now how do I pay for long-term care? You can private pay. You know, if you're fortunate enough to have the resources to be able to write $15,000 checks to the nursing home every month, you can absolutely do that. If you have long-term care insurance, that should cover a portion of that private pay bill, and then that'll be supplemented by your other assets. But again, if you can't private pay and you don't have long-term care insurance, likely you are going to try to qualify for Mass Health to cover the cost of your nursing home stay. So what is Medicaid or Mass Health? So Medicaid is what it's called federally. Mass Health is what we call it here in Massachusetts. And it's financial assistance for nursing home and some at-home assistance. Don't confuse it with Medicare. Medicare does not pay for long-term care. Medicare, will pay for a hospital stay. It'll pay for you to go to the doctor. And if you need some short-term rehab, so if you've had a fall and you went to the hospital for 3 nights and you transition to a skilled nursing facility for rehab, Medicare will pay up to 100 days. They pay the first 20 days in full, and then the remaining time that you get, which you're not guaranteed all 100 days, is covered by Medicare, and then typically the copay is picked up by any supplemental health insurance that you might have. But once you've exhausted your Medicare stay, whether it's at day 70 or day 100, even if you continue to need rehab, Medicare is no longer going to pay. So then you're faced with, can I private pay? Do I have long-term care insurance? Or do I need to take steps to help me qualify for Mass Health? In order to be eligible for Mass Health, the person who needs the care can't have more than $2,000 in countable assets. And we're going to talk in just a moment about what's countable versus non-countable. If you are married, your spouse who is still living in the community can have up to just over $154,000 in countable assets. And the $2,000 has remained constant throughout my almost 20 years with the firm, but the amount that the spouse is able to keep goes up a little bit each year. It's indexed for inflation, so that increases a little bit from year to year. So what is countable versus non-countable? Tangible personal property, such as your furniture, clothing, jewelry, that is non-countable. You can own one vehicle, regardless of its value. Your primary residence is non-countable. If you have a prepaid irrevocable funeral plan, that's non-countable. If you have life insurance that has a face value of less than $1,500, that's non-countable. And if you have a burial account, which is essentially a savings account at your local bank earmarked for things that the funeral plan may not cover, those are your non-countable assets. Everything else counts. So your checking accounts, your savings accounts, CDs, IRAs, 401ks, the second vehicle, the condo down in Florida, all of those are your countable assets for Mass Health eligibility purposes. So Mass Health looks at the value of all of those assets in determining whether or not you're eligible. Now, that's where those specific planning strategies I mentioned come into play. So there's different strategies that we can employ to get you to the place where you need to be in order for Mass Health to find you eligible and cover your nursing home stay. When you're applying for Mass Health, there is something called a 5-year look-back period. So when you apply, Mass Health has the right to look back into your records for 5 years. That's the look-back period. So they're looking to see, did you give anything away in an attempt to impoverish yourself? And if you did, then they will impose something called a penalty period, which is a period of time that they won't pay for your long-term care based on the total value of what you gave away. Now, there's lots of exceptions to those transfer rules, and we'll talk about those in just a second. But a frequent question that we get is, I thought I could give away $18,000 per year, and that was fine to do. That is a generous rule from the IRS. Mass Health is not so generous. If you've given away anything of value, they can impose a penalty period for that. So the same $18,000 that you give away that the IRS is perfectly fine with, it's going to be a problem for Mass Health purposes. Now, as I mentioned, there are some exceptions to those Mass Health transfer rules. So transfers between spouses won't have any implication for the look back period. So even on the eve of a nursing home stay, you can transfer assets between spouses and there's no eligibility implications. If you have a blind, disabled, or minor child, you can transfer assets to that person either outright, or if they have their own eligibility issues, perhaps in a trust for their benefit, and there's no penalty period for that. If you have two siblings who live together, who each own an interest in the property, the sicker sibling can transfer their ownership interest to the healthier sibling without any penalty. And then if you have something called a caretaker child, you can transfer your home to that person without any penalty. Now, the Mass Health regulations define a caretaker child as your biological or legally adopted child, so it can't be a stepchild, it can't be a grandchild, who has lived in your home with you for the 2 years, at least the 2 years, immediately preceding your having needed long-term care. And for at least those 2 years, they essentially provided care for you that kept you at home rather than in the long-term care facility. So a really important piece to focus on in that definition is the fact that they needed to have lived with you and provided the care for the 2 years immediately preceding your having needed long-term care. So if your child has been living with you for the last 10 years and been providing care for you, and then you transition to an assisted living for a year, and then you need to go to long-term care, that hop over at the assisted living unfortunately destroyed the caretaker child status. So you have to have gone from home to the long-term care facility in order for that caretaker child exception to apply.
Can I just interject real quick, Erin?
Sure.
So I just want to say, because I know everybody here doesn't live in Massachusetts, and every state has their own kind of program for how Medicaid works. But I think the strategies are going to be very similar. So even though this is going to be tailored specifically to people in Massachusetts, a lot of it's going to apply to all of you. So just wanted to say that.
Sure, that's absolutely right. I mean, from state to state, there are little differences in the Medicaid regulations. For instance, if you are a Rhode Island resident, retirement plans are not countable assets for Medicaid purposes. That's a really significant difference in Rhode Island's rules versus Massachusetts rules. Now, I don't practice in Rhode Island, so I can't speak to all the differences, but I know that that is a pretty significant difference between our Medicaid rules and Rhode Island's Medicaid rules, for instance. But now we're going to talk a little bit about trusts, irrevocable versus revocable trusts, estate taxes, and some retirement planning considerations. So what does a trust do? One trust may not solve all of your estate planning concerns. So you may be concerned about the cost of long-term care, and you might also have a beneficiary who has a disability. So it's not uncommon to see an estate plan that includes more than one type of trust because they're doing different things. Trusts are designed to achieve your specific goals. So what's written in the trust dictates the purpose of the trust and how it's meant to be administered. Now, I've heard from lots of people that say, you know, my this or my that said I didn't need a trust. And, you know, because the size of my estate doesn't warrant it. But the size of your estate, in my opinion, is not really the determining factor in whether or not a trust is a good fit for you. It really depends on what your goals are for the assets that you own. So, for example, two families might come in to meet with us, family A and family B. On paper, they look exactly the same. They've got a house worth $500,000. They've got $300,000 in liquidity. But family A comes in and they say, you know, my family is doing well for themselves. I'm not concerned about leaving an inheritance behind. If I have to spend every penny of money on my own care, I'm perfectly happy to do that. That's my goal. So for that family, I'm not going to recommend an irrevocable trust, which is designed to protect assets from the cost of long-term care. They might be more appropriate for a revocable trust to avoid probate. Family B comes in, same assets, and they tell me, you know, come hell or high water, I want to make sure that I'm leaving my house to my family. That's going to be a family that might be appropriate for an irrevocable trust. So, it doesn't matter what your estate necessarily consists of. It matters what your concerns are and what your goals are. And we will tailor your planning to help you achieve those goals. Now, if you have a trust in place already, I strongly recommend that you dust it off and you take a look at it. There are so many times that people bring their old estate planning documents to us, specifically trusts, and say, I did my trust 20 years ago. I got through my 5-year look back period. So my house is protected if I go into a nursing home, right? And I take a look at it and I say, unfortunately, no. What you have is a revocable living trust. Revocable living trusts do not protect your assets from the cost of long-term care. So it's really critical that you understand what your trust is doing for you and what it isn't doing for you. And remember that, when you put it in place 20 years ago, you may have had different goals than you do today. So maybe 20 years ago, that was a perfectly appropriate recommendation and there was a reason you made that choice, but you haven't looked at it in 20 years and now your life has changed and your concerns are different. So you want to make sure that you continuously revisit your planning. Clients of our office get invited back in every 3 years for a free review meeting. It's just an opportunity for us to be able to refresh their memory on what they put in place and why, what it's doing for them, what it's not doing for them, address any changes in the law in their life. If you're going to invest in estate planning, you want to make sure that when the time comes for it to work for you, it actually works in the way that you want it to. So it's really important that you continue to revisit your estate planning every few years. Now, the two main trusts that we've been talking about are irrevocable trusts and revocable trusts. Think of your revocable trust like a basket and your irrevocable trust like an umbrella. So both types of trusts can do a lot of the same things. Both can avoid probate, both can minimize taxes, provide creditor and divorce protection for your beneficiaries, provide for beneficiaries who might be incapacitated or who have a disability. So there's a lot that they have in common. But the primary difference between the two trusts is the access to principal. So with a revocable living trust, you generally are the grantor. You're the person who creates the trust. You're the trustee, so you're in charge of it, and you're the beneficiary of it during your lifetime. But because you have such unfettered access and control of the assets in a revocable living trust, you don't have any long-term care protections. To get that, you would need an irrevocable trust. So with an irrevocable trust, you choose who your trustees are, you choose who your beneficiaries are. If it's your home that's in the trust, you have the right to live in the home for your whole life. You're still responsible for the same things you were before you had the trust, the water bills and the tax bills and things like that. The property can be sold. That's what a lot of people, I think, are afraid of. If I put my house into an irrevocable trust, I'm stuck here for the rest of my life. That's not true. So again, think of the irrevocable trust like an umbrella. So if you were putting your home under that protective umbrella, that would get the 5-year clock ticking towards protecting that asset from the cost of your long-term care. After you set up the trust, 2 years later, 10 years later, you decide you just want to downsize. You don't want to shovel anymore. You want to live in a little condo. That is absolutely possible. So whoever you've chosen to be the trustee of your trust would sell your current property. Let's say they get $500,000 from the sale of that property. So now under that protective umbrella is a $500,000 bank account that represents the sale proceeds. Your trustee can then take, let's say, $300,000 of that and use it to purchase the condo that you want to live in. That condo is going to be owned by the irrevocable trust. So because during those transactions, nothing came out from underneath that protective umbrella, you're not starting and stopping your 5-year look back period. That new condo and that money that's in the bank is going to have the same retroactive start date of protection as when you put your original property into the trust. Now, if there's some cash sitting in there, you can't have direct access to it. So that's what you give up in exchange for your protection from the nursing home. So if you put your home in, let's say, for instance, you are giving up the equity, the ability to tap into the equity that you have in your home. So you can't get a mortgage, you can't get a reverse mortgage, a home equity line of credit. So for people who are considering an irrevocable trust, we always look at, do you have enough income or other assets, liquidity outside of the trust, that if you needed to replace the roof or the boiler let go, that you can tap into those resources without needing to tap into the equity in the home. So that's really the primary difference between the two. The irrevocable trust gets you the nursing home protection once you get through the 5-year look back period, but you give up the ability to tap into the equity. The revocable trust, you have complete access to everything that's in it, use it any way you want, but you don't get the associated nursing home protection that you would get with the irrevocable trust. Now, the good news about estate taxes is that recently Massachusetts increased its estate tax exemption amount to $2 million. It was $1 million for a very long time, but now it has increased to $2 million. So if you pass away as a Massachusetts resident and your estate is valued at less than $2 million, you're not going to have to pay any estate taxes, or your estate's not going to pay any estate taxes. If it is over $2 million, and you have done no planning to try to minimize the taxes, then everything over the $2 million threshold is going to be taxed by the Commonwealth before it gets to your beneficiaries. Now, federally, that exemption amount is much, much higher. Right now, it's $13.61 million per individual and over $27 million per couple. So I'll be honest, for most of my clients, they are not concerned about having a federally taxable estate, but they are concerned about having a Massachusetts taxable estate. Your taxable estate includes everything that you have an ownership interest in when you pass away. So even if it's in a trust, even if it has a beneficiary designation on it, that counts as part of your taxable estate. And what a lot of people don't know is it includes the death benefit of your life insurance. So, if you've got $1 million policy, you're already halfway to the exemption amount, not even including the value of your home or retirement accounts or anything like that. So it's easier to have a taxable estate than a lot of people might realize. So there are planning strategies that we can use, generally trust planning, to minimize those estate taxes. Especially for a married couple, If your combined estate is over $2 million, we can use trust planning to make sure that we maximize both spouses' $2 million exemptions. So for example, if you have a $2.5 million estate between the two of you, and you do no planning whatsoever, generally when the first spouse passes, no taxes are going to be owed. Everything's going to flow over to the surviving spouse. But then when that spouse passes, now their estate is over $2 million. So that $500,000 is going to get taxed by the Commonwealth. There is trust planning that we can use to make sure that we don't just let go of that first spouse's $2 million exemption. So we can essentially wipe out taxes as long as your combined estate is below $4 million. And if you're fortunate enough to have assets above 4 million, that trust planning is going to significantly minimize the estate taxes that would be owed when the first and second spouse pass. And now some retirement planning considerations. As we talked about, the cost of long-term care is significant. So it's really important to focus on the whole picture when you're looking at your retirement planning, because those healthcare costs are going to have a significant implication on your overall savings. So it's really important to make sure that your estate planning attorney, your accountant, your financial advisor are coordinating their efforts in that regard. Things like IRAs, 401ks, 403bs, those are the most significantly difficult assets to protect from the cost of long-term care. And the reason for that is because of the tax implications. So you can't simply put your 401k into a trust or your IRA into a trust without incurring income taxes. So if you were to change the ownership of an IRA, let's say, to your trust, the IRS would view that as an entire liquidation of the account and would consider all of that income to you in that year. So you would be potentially hit with a lot of income taxes. So generally, we try to protect other assets if that's a concern of yours, while leaving your ability to access your retirement accounts so that you can pay for, things in your retirement years. Brendan, did you have anything you wanted to add about things to consider for retirement planning?
Not specifically, but just want to reiterate. I mean, those of you who work with me know, we spend so much time planning your retirement and you all spend so much time saving for retirement, setting yourselves up. And if we don't have this component in place, the whole thing doesn't work. So it's every bit as important as the tax planning that we do and the investments that we do to have this all figured out. So I will just say that.
Great. So our last topic, our last substantive topic is special needs planning. So for families that have a disabled beneficiary, very often there's an informal plan in place. That beneficiary is essentially cut out of the estate plan and everything is left, let's say, to the sibling. So it is the family's intention that that sibling is going to share the assets with the disabled person as needed. Now, even if that sibling has the very best of intentions, there may be situations that arise in their life that prevent them from being able to do that. What if they unexpectedly pass first and now those assets are going to their spouse or their children? What if they get divorced and their divorcing spouse tries to come after it? What if they have a creditor issue or get in an accident and get sued? Those are all very possible scenarios that could happen that would prevent the sibling from being able to share with the disabled sibling in the way that you had intended. So rather than relying on that informal plan and the inherent risks in it, I would recommend that you include that disabled beneficiary as part of the estate plan, but send their share to them in something referred to either as a special needs trust or a supplemental needs trust. And what that is designed to do is to essentially provide a nest egg for the disabled beneficiary. So it allows them to still qualify for any needs-based benefits that they may be entitled to. You know, if they're getting mass health or housing or SSI benefits, they can still get all those benefits, but the inheritance that you left for them in the trust can be used to supplement it. So to give them the very best quality of life possible. You know, if there's additional therapies they need, if there are activities that they like to participate in, those funds can be used to support those things. So that is a really critical way to make sure that your disabled loved one gets provided for in the way that you intend. So that wraps up the substantive part of the program from me. Often we get questions at the end of the program about, you know, what does it look like when I work with your office? So I'd like to address some of those frequently asked questions right off the bat. How long does it take to complete my estate planning project? On average, it takes about 6 to 8 weeks from the initial consultation that we have through the review process, and then when we meet to sign the documents. How does your office help me keep my plans up to date? As I mentioned, we offer that free 3-year review meeting, and we send a letter out to all of those clients and invite them to come back in for that meeting. It's typically about 30 minutes, so we offer that to everyone. When I meet with you, can I bring someone? Absolutely. So as you've probably discovered through the program, this is complicated stuff. So for you to come to a consultation, learn a bunch of information, and then go to try to relay it to someone else, something is likely going to be lost in translation. So if there is anyone that you need to have present in the meeting to feel comfortable in moving forward with recommendations, we encourage you to bring them to the meeting. If they cannot physically be there in person, we can conference call them in, we can get them on a Zoom if we need to. But it is really important and helpful to have everyone who will be involved in the plan available so that they can ask questions and be a second set of ears for you. And then lastly, how much does an estate plan cost? So I'm truly not trying to dodge the question, but it really does depend. So if you came in and you said, all I need are the foundational documents, I don't care about anything else, that's going to have a much smaller price tag than if you come in and you say, I want to protect my house from the cost of long-term care. Oh, my estate is just over $2 million, and I have a beneficiary who is disabled. That's going to carry a much more significant price tag. But if you decide you want to set up a consultation with our office, one, we provide you with a $250 discount certificate, good off any trust planning that you may move forward with. But also we provide you with our pricing brochure. So it goes through some of the common areas of planning that we provide, and it helps you kind of self-identify where you think you might fall based on your own particular concerns, and it gives you a price range for that type of planning. So when you come in to meet with one of the attorneys, you are going to have a ballpark idea of what that planning might cost you. And the consultation is free and there's no obligation. So, you know, I would encourage everyone who has taken the time tonight to maybe stop procrastinating and start to move the ball forward on this, to, you know, take advantage of that consultation, continue to educate yourself and have these concepts applied to your specific situation so that you can make an educated decision about how you want to move forward with your estate planning. If you are interested in setting up a consultation, you are welcome to either put your name and phone number in the chat, or at the end of the slides is our contact information. You can reach out to the office by phone, or you can send an email, and then someone from our client services team will reach out to you to coordinate a date and time that works for you.
All right. Well, thank you so much, Erin.
Thank you for
I just,
having me. I appreciate
yeah,
it.
absolutely. Just want to wrap up, and we're going to get to some Q&A after this, but just want to say for everybody on here who I'm already working with, or if we aren't yet working together, next time we speak, we'll factor in this estate planning because there's a lot when it comes to your retirement and investment plan that has a big impact on your estate plan and vice versa. So these things kind of go hand in hand, and it's important to have a team around you that communicates with each other to make sure everything is in the right place and is going to go to the right place when you need it. So, yeah, thank you very much, Erin. I think we had at least one question.
Sure, let me see if I can pull that up.
But yeah.
The question is, could you speak to planning for inheritances from family? Would they be best protected putting into a trust? So I'm not entirely clear on the question. So if you've already received an inheritance from someone, that is now an asset of yours. And whether or not it should go into a trust will really depend on what your goal is for that particular asset. You know, if you want to avoid probate and provide structure for your beneficiaries, a revocable trust might be a good fit. If you think, you know, this was kind of a windfall and I don't necessarily need to have access to this in my retirement years and I'd like to be able to further pass it on, then maybe an irrevocable trust would be a good fit. If the scenario is someone is leaving me an inheritance and should they leave it for me in trust, I would say yes. For clients of ours who are looking to leave inheritances behind for beneficiaries, it can either be done outright, meaning that beneficiary gets whatever share they're going to get and they can do whatever they want with it, or they can leave it in an ongoing trust for that beneficiary's benefit in something called a personal asset trust. And that type of trust allows the beneficiary to have the benefit of the inheritance, but without incurring the risks associated with individual ownership. So assets that are left to a beneficiary in a personal asset trust are designed to be protected from things like divorce and creditors, and to make sure that those assets stay in your family's bloodline. So I hope that answers that question. Okay, Ira's nodding. Okay, good. Does anyone else have any questions or comments that they'd like to raise? Oh, thank you, Karen. I'm glad you found it helpful.
Yeah, you can unmute yourself if you want to speak up or write it in the chat, or nobody has any questions, that's okay too.
Yeah, if not, I just want to, again, thank everyone for taking the time out of their night to come and learn some of this information. There's so much misinformation out there that every opportunity that we can get to try to provide good, solid, reliable information for people, we're really very excited and happy to be able to do that. So again, my contact information is up on the screen. So if you're interested in setting up a consultation, but you're not comfortable putting your contact information in the chat, you are welcome to reach out to us directly, and we'll get that set up for you. I hope that I get to see all of you in the future.
Thank you so much, Erin.
Thank you, Brendan.
Appreciate it.